Welcome to Washington, D.C. Marijuana Laws. Learning objectives. Legalized by the passage of the Legalization of Marijuana for Medical Treatment Amendment Act, Washington, D.C. allows residents, including minors, to be prescribed, purchased, possess, and use marijuana to treat a diagnosed qualifying medical condition or related side effect. Marijuana remains prohibited on federal land, however. The federal government owns about one-third of the land in Washington, D.C., which includes national parks like Rock Creek Park and the National Mall, military buildings, and government buildings. Since marijuana remains federally illegal, consumers may face federal penalties if caught with marijuana in these areas. D.C. residents may apply for patient registration to be eligible to purchase cannabis from any licensed dispensaries. Upon submission of an application, applicants receive a temporary digital registration that allows them to purchase cannabis for up to 30 days, while their application is under review. Non-D.C. residents may purchase medical cannabis from a licensed dispensary by applying for a temporary registration or by presenting their patient registration from a U.S. state or territory that extends reciprocity. Learning objectives. Washington, D.C. history. Regulated medical marijuana. Residency requirements. Qualifying patients. Medical marijuana caregivers. Patient and caregiver eligibility. Legal penalties. Possession and administration. Use and limitations. Dispensaries and cultivation centers. Investigations and inspections. Operating requirements. Operational hours and non-operating hours, manager registration, disposal and theft, labeling and packaging. Ingestible marijuana products, security surveillance, security alarm system, valid photo identification, sign requirements, staffing and facility lighting, limited access areas. Manufacturing standards, allowed pesticides, marijuana transportation, marijuana delivery and plant limitations, on-premise consumption, agent entry requirements, marijuana and paraphernalia and visibility, advertising, promotion and marketing, records and reports, cannabis driving and impairment. Washington, D.C. history. Washington, D.C. residents voted in favor of medical marijuana in 1998 via Initiative 59. But Congressman Bob Barr blocked implementing the program via the infamous Bair Amendment. It was tacked onto the Omnibus Consolidated and Emergency Supplemental Appropriations Act. The amendment made it illegal to conduct any ballot initiative which seeks to legalize or reduce penalties with the possession, use, or distribution of any Schedule I substance under the Controlled Substances Act or CSA, or any tetrahydrocannabinol, or THC, derivative. The D.C. Council passed the Legalization of Marijuana for Medical Treatment Amendment Act in 1999, which clarified the provisions of the prior legislation and established regulations for dispensaries, and the legislation set possession limits for medical patients. The Medical Marijuana Expansion Emergency Amendment Act of 2014 expanded eligibility for a medical card to encompass any condition that a physician believes could be alleviated by medical marijuana. The Medical Marijuana Reciprocity Amendment Act of 2015 allowed patients from other jurisdictions with equivalent medical marijuana programs to use their cards at dispensaries. In 2019, D.C. began accepting medical marijuana cards from any other state. Non-D.C. residents are ineligible to register in D.C.'s medical cannabis program, but may continue to purchase cannabis from a D.C. licensed dispensary if they are a patient in a medical cannabis program that extends reciprocity. The Medical Marijuana Self-Certification Emergency Amendment Act of 2022, signed into law by the mayor, authorized temporary registrations and self-certification by D.C. residents at least 21 years of age and older. Residency requirements. Washington, D.C. residents may purchase medical cannabis from any licensed dispensary with patient registration, and including minors who are eligible for patient registration. And registrations are valid for up to 2 years from the date of issuance. Minors or underage, parents or guardians of minors, 17 years of age or younger, must submit a minor medical cannabis patient application that includes a healthcare recommendation number and an identified registered caregiver. Adults aged 18 to 20, adult applicants 18 plus, must apply using an adult medical cannabis patient application. Persons between 18 and 20 years of age are not allowed to self-certify and must include a healthcare recommendation number in their application. Adults aged 21 plus, persons at least 21 years of age may self-certify their application instead of receiving a healthcare provider recommendation. Online applicants can select this self-certification option under certification type. Online applicants will promptly be emailed a temporary digital registration that they may use to purchase cannabis, effective immediately for up to 30 days, while their application is under review. A permanent physical and digital registration will be sent to applicants, if approved. In person, applicants are issued a permanent digital and physical registration during their visit. If approved, digital and physical registrations may be used interchangeably at licensed dispensaries. Registration in DC's medical cannabis program is restricted to residents, and to substantiate residency, you must submit one proof of residency with your application. Qualifying patients. To qualify for a patient registry identification card, 1. A resident of Washington, D.C. at the time of application, and remains a bona fide resident during treatment with medical marijuana. 2. Have a medical condition or be undergoing medical treatment. 3. Have a signed written physician's recommendation to use marijuana. 4. If the patient is a minor, the signed written consent of their parent or legal guardian is. A patient will be a resident of D.C. if the individual 1. Is physically present in D.C. 2. Has taken verifiable actions to make D.C. their home indefinitely, with no present intent to reside elsewhere. 3. It is not merely present in D.C. for the sole purpose of obtaining marijuana. Medical marijuana caregivers. A caregiver will only possess and dispense medical marijuana to a qualifying patient, and possess and use paraphernalia for the sole purpose of assisting in its administration to a patient. To qualify for a caregiver registration identification card, an applicant will 1. Be designated by a patient to serve as the person authorized, on their behalf, to possess, obtain from a dispensary, dispense, and assist in the administration of marijuana. 2. Be registered with the Department of Health or DOH as the patient's caregiver. 3. Not currently serving as the caregiver for another patient. 4. Be at least 18 years of age. 5. Have never been convicted of possession or sale of a controlled substance, unless such conviction occurred after the act's effective date and was related to the possession of marijuana. A caregiver will only obtain marijuana for the patient from the dispensary, designated on their registration identification card, and will not grow or cultivate marijuana for the patient, purchase marijuana through street vendors, obtain marijuana from other patients and caregivers. If a patient changes their designated dispensary or makes a change to the information set forth on their registration card, both the patient and the caregiver must surrender their registration identification cards to the DOH and obtain new cards reflecting the change. Patient and caregiver eligibility. A qualifying patient or caregiver who is no longer registered with the program or eligible for registration with the program will, within 14 calendar days after they cease to be registered or eligible for registration with the Department of Health or DOH, return any unused medical marijuana in their possession to the Metropolitan Police Department or MPD. Registration has been summarily suspended or revoked by the DOH within 24 hours after receiving notice of the suspension or revocation. return any unused marijuana in their possession to the MPD. Is no longer registered with the DOH, will not transfer, share, give, or deliver any unused marijuana in its possession to another patient or caregiver for medical use or destruction, whether or not the person is registered with DC's Medical Marijuana Program or MMP. A patient or caregiver will not dispose of marijuana in any manner other than allowed by law. Legal penalties. Any person who manufactures, cultivates, possesses, administers, dispenses, distributes, or uses marijuana or manufactures, possesses, distributes, or uses paraphernalia in a manner not authorized by the law will be subject to criminal prosecution and sanction. Any person who makes a fraudulent representation to a law enforcement official of any fact or circumstance relating to the person's use of medical marijuana or use of paraphernalia to avoid arrest or prosecution will be subject to a criminal fine, not to exceed $1,000. The imposition of the fine will be in addition to any other penalties that may apply for making a false statement. It will be an affirmative defense to a criminal charge of possession or distribution of marijuana, or possession with intent to distribute marijuana, that the person charged with the offense is a person who 1. Had marijuana only inside the patient's residence or a medical treatment facility. 2. Only administered or assisted in administering the marijuana to the patient, and only within their residence or at an allowed medical treatment facility. 3. Assisted the patient only when the caregiver was not reasonably available to assist. 4. Is 18 years of age or older. Possession and administration. A qualifying patient will only possess and administer medical marijuana, or use paraphernalia for treatment of a medical condition or the side effects of the treatment after 1. Obtaining a signed written recommendation from a physician. 2. Register with the Department of Health or DOH. A patient or caregiver will only possess, administer, or dispense marijuana, or possess or use paraphernalia obtained from the registered dispensary, designated on their registration identification card. Transport marijuana in a container or sealed package bearing the label received from the dispensary. Not administer or use marijuana at a dispensary or cultivation center, and it will not be used by a patient anywhere other than patient residence, medical treatment facility, if allowed. Use and limitations. A qualifying patient will not use medical marijuana at a time or in a location within their residence, when such use would result or is likely to result in exposure to the marijuana, or the smoke that may adversely affect the health, safety, or welfare of a minor. A patient who is a minor will only possess and administer marijuana if the parent or legal guardian of the minor has signed a written statement affirming that they 1. Understands the qualifying medical condition or treatment of the minor. 2. Understands the potential benefits and potential adverse effects of marijuana use in general, and specifically in the case of the minor. 3. Consents to use marijuana for the treatment of the minor's medical condition or treatment of the side effects. 4. Consents or designates another adult to serve as the caregiver for the patient, and the caregiver controls the acquisition, possession, dosage, and frequency of marijuana use for them. Nothing will be construed as permitting a patient to 1. Undertake any task under the influence of marijuana when doing so would constitute negligence or professional malpractice. 2. Operate, navigate, or be in actual physical control of any motor vehicle, aircraft, or motorboat while under the influence of marijuana. A dispensary will have the right to refuse service to a patient or caregiver who 1. Engages in abusive, intimidating, threatening, or disruptive conduct while on the premises of a dispensary. 2. Presents a registration identification card that appears to have been tampered with or altered. 3. For other good causes shown. After refusing to provide service to a patient or caregiver, the dispensary will notify the Department of Health or DOH in writing within 24 hours or 1 business day of refusing service, and provide full information and details as to the basis for the refusal. No patient or caregiver will use butane or other explosive gases to extract or separate the resin from tetrahydrocannabinol, or THC, marijuana, or in any other manner. Dispensaries and cultivation centers. Review the differences between licensed operations. Dispensary may possess medical marijuana for dispensing to a qualifying patient or caregiver and may manufacture, purchase, possess, distribute, and use paraphernalia. Cultivation center may cultivate and possess marijuana for distribution to a dispensary and may manufacture, purchase, possess, and use paraphernalia. Testing laboratory may possess marijuana for testing its contents. A dispensary may dispense marijuana and distribute paraphernalia only to a registered patient or as their caregiver from that dispensary. Each dispensary, cultivation center, and testing laboratory will be registered with Alcoholic Beverage Regulation Administration or ABRA before manufacturing, cultivating, dispensing, possessing, testing, or distributing marijuana or paraphernalia. A cultivation center will not possess more than 1,000 living marijuana plants at any time. It will be unlawful for a dispensary to dispense or possess more than the quantity of marijuana needed to support the number of patients or caregivers registered to receive marijuana at that dispensary. No marijuana or paraphernalia at a dispensary, cultivation center, or testing laboratory will be visible from any public or other property. A dispensary, cultivation center, or testing laboratory will not be located within any residential district or 300 feet of a preschool, primary or secondary school, or recreation center. A cultivation center will not be located within a retail priority area. Each dispensary, cultivation center, and testing laboratory will 1. Be either a for-profit or non-profit corporation incorporated within D.C. 2. Implement a security plan to prevent marijuana theft or diversion, including maintaining all of it in a secure locked room that is accessible only by authorized persons. 3. Ensure that all of its employees receive training on compliance with D.C. law, marijuana use, security, and theft prevention. Each dispensary will regularly distribute to all patients and caregivers the educational materials regarding potential harmful drug interactions developed as part of the program. Investigations and inspections. The Department of Health or DOH may conduct announced and unannounced investigations and inspections of cultivation centers and dispensaries. It is the DOH's mission and function to determine the suitability of any facility or location for sanitation and health, to determine legal compliance by any registered cultivation center or dispensary. Failure by a dispensary or cultivation center to provide the DOH with immediate access to any requested material or information may result in the imposition of a civil fine, as well as a referral to the Alcoholic Beverage Control or ABC Board for further sanctions. Dispensary. During an inspection or investigation of a dispensary, the DOH may review the dispensary's confidential records, including its dispensing records and information, which contains the names and addresses of patients, caregivers, and recommending physicians. Cultivation Center. During an inspection or investigation of a cultivation center, the DOH may review the cultivation center's confidential records as necessary and appropriate to determine compliance with regulations. Patients and caregivers. All patients and caregivers will provide the DOH or its agents with immediate access to any material and information necessary for the inspection. Failure by a patient or caregiver to provide them with immediate access to any requested material or information may result in sanctions against the patient or caregiver up to and including revocation of registration and referral to local law enforcement. Operating requirements. Posting ID requirement. An identification ID notice is required to be posted in a dispensary that states no person will be sold medical marijuana who does not produce both. 1. A valid registration card was issued by the Department of Health or DOH. 2. A valid government-issued photo identification document is displaying proof of age that matches the name on the registration card. Operational hours. A registered medical marijuana dispensary may operate and sell marijuana on any day and at any time, except between the hours of 9 p.m. and 7 a.m. A registered cultivation center will not be open to the public, and if a registered cultivation center and registered dispensary are located in the same building, the portion of the building occupied by the cultivation center will be closed to the public. A cultivation center may operate its business 24 hours a day, so a cultivation center or its contracted agent may deliver to marijuana dispensaries on any day and at any time, except between the hours of 9 p.m. and 7 a.m. A registered cultivation center will permit only a registered director, officer, member, incorporator, agent, manager, employee, or government or law enforcement official on the registered premises. Non-operating hours. A registered dispensary or cultivation center will keep all medical marijuana located on the premises in a separate storage area, which is securely closed and locked during all hours when the establishment is prohibited from operating or is closed. The storage area will have a volumetric intrusion detection device installed and connected to the facility intrusion detection system. A cultivation center or dispensary will be required to install and use a safe for overnight storage of any processed marijuana, transaction records, and cash on the registered premises. The safe will be a UL-listed burglar-proof safe with the minimum rating of TL30, which refers to at least 30 minutes it can withstand during a sophisticated criminal attack. Safes weighing less than 750 pounds will be installed in a steel-clad concrete block or securely anchored to the facility structure. Manager registration. In the absence of an owner, a cultivation center or dispensary will have a Department of Health or DOH approved manager present at the registered premises during the hours that the cultivation center or dispensary is open. An applicant for a manager's registration will submit an application to the DOH on the prescribed form and pay the required fee. An applicant for a manager's registration will be subject to the requirements and the approval of the DOH, and before issuing a manager's registration, an applicant will certify that they have obtained and read a copy of the laws. A registered cultivation center or dispensary will notify the DOH within 7 calendar days of discovering any manager's arrest or conviction for any crime other than minor traffic violations. Failure by the applicant to comply may cause the applicant's registration to be suspended or revoked. Disposal and theft. A cultivation center or dispensary will destroy or dispose of unused or surplus medical marijuana and its byproducts by providing it to the Metropolitan Police Department, or MPD, for destruction. All unused or surplus marijuana and its byproducts will be weighed, documented, and submitted to MPD on a form provided before being delivered for destruction. A cultivation center or dispensary that has had its registration renewal denied, revoked, or is going out of business may obtain approval from the Department of Health or DOH by submitting a written request to sell and transport marijuana to another cultivation center or dispensary. The DOH will notify MPD of such approval before any marijuana is transported to another cultivation center or dispensary. A cultivation center or dispensary will report any stolen or lost marijuana by filing a police report, by calling emergency services or in person with the police, where the registered business resides either in person or in writing within 24 hours of becoming aware of the theft or loss. Unused or surplus medical marijuana will be defined as any harvested or unharvested marijuana, both processed and unprocessed, which is possessed by a cultivation center or dispensary and includes any marijuana plants possessed by a cultivation center above the authorized plant limitation, any marijuana that has spoiled or is unusable for medical purposes, any marijuana possessed by a dispensary above the amount needed to supply all of the dispensary's patients for a 1-month period, and any marijuana that has or appears to have been tampered with. The DOH may allow a dispensary to possess a marijuana surplus for some time, if it is shown that there is a likelihood that additional patients or caregivers will register with the dispensary. Labeling and packaging. No medical marijuana will be dispensed or distributed to a qualifying patient or caregiver unless the container in which it is distributed bears a legible label, firmly affixed, stating cultivation center name where the marijuana was produced and the manufacture date, dispensary name where the marijuana was dispensed, quantity of marijuana contained, cannabinoid profile, including the tetrahydrocannabinol or THC level, any other ingredients contained, name of the recommending physician, dispensing date to the patient or caregiver, patient's name and registration card number, a statement that the product is for medical use, not for resale or transfer to another person, containing the following language. Contains marijuana. Keep out of the reach of children. All marijuana sold or distributed by a cultivation center will be packaged and labeled in a manner that advises the purchaser that it contains marijuana, specifies the amount in the product, and that the marijuana is intended for medical use solely by the patient to whom it is sold, and that any resale or redistribution of the marijuana to a third person is prohibited. The label will include all ingredients contained in the product in order from most abundant to least abundant. The label for ingestible items will identify potential food allergy ingredients, including milk, eggs, fish, shellfish, tree nuts, peanuts, wheat, and soybeans. The product will be packaged in a sealed container that cannot be opened without obvious damage to the packaging. The label will contain the following warning. There may be health risks associated with the ingestion or use of this product. Please consult your physician if you have any questions or concerns. All marijuana will be labeled with a list of all chemical additives, including non-organic and organic pesticides, herbicides, and fertilizers that were used in cultivation and production. A cultivation center may place a trade or product name on the marijuana container before transporting it to a dispensary. Labeling requirements. The label will not contain any of the following information: any false or misleading statement or design, any seal, flag, crest, coat of arms, or other insignia, likely to mislead the qualified patient to believe that the product has been endorsed, made, or used by the DC government. A dispensary will place for transport purposes packaged and labeled medical marijuana in a separate sealed container before dispensing marijuana to a patient or caregiver. This separate sealed container will include a label containing the following required information: the dispensing date of the marijuana was transferred to the patient or caregiver, the patient's name and registration card number. A cultivation center or dispensary will not alter, obliterate, or destroy any label attached to a container. Use the words candy or candies on the product, packaging, or labeling of any marijuana product. Place any content, image, or labeling that specifically targets individuals under the age of 21, including cartoon characters or similar images, on the product, packaging, or a container holding marijuana. A cultivation center that produces edible marijuana products or marijuana-infused products will ensure that all edible marijuana products or marijuana-infused products are offered for sale. They are labeled clearly and unambiguously as marijuana, are not presented in packaging or with labeling that is appealing to children, have packaging designed or constructed to be significantly difficult for children under 5 years of age to open, but not normally difficult for adults to use properly. A cultivation center or dispensary will not use or allow the use of any content, image, or labeling on a marijuana product that is offered for sale, if the container does not precisely indicate the nature of the contents, or that in any way may deceive a customer as to the nature, composition, quantity, age, or quality of the product. Packaging of edible or infused marijuana products will not bear any resemblance to the trademark, characteristic, or product specialized packaging of any commercially available candy, snack, baked good, or beverage. Statement, artwork, or design that could reasonably mislead any person to believe that the package contains anything other than an edible or infused product. Seal, flag, crest, coat of arms, or other insignia that could reasonably mislead any person to believe that the product has been endorsed, manufactured, or used by any state, county or municipality, or any agency thereof. Ingestible marijuana products. The production of any medical marijuana distributed by a dispensary in an edible form, or other forms which are intended to enter the body of a patient, will be prepared at a cultivation center facility that meets all requirements of a retail food establishment, including any licensing and/or certification requirements. The production of any product containing marijuana will comply with all Washington, D.C. health regulations relating to the production, preparation, and sale of prepared food items. Marijuana-infused products that require cooking or baking by the consumer are prohibited. Marijuana-infused products that are especially appealing to children are prohibited. Marijuana-infused edible products, such as gummy candies, lollipops, cotton candy, or brightly colored products, are prohibited. A cultivation center will not process or transfer a marijuana item that 1. Its shape, design, or flavor is likely to appeal to minors, including products that are modeled after non-cannabis products are primarily consumed by and marketed to children. Products in the shape of an animal, vehicle, person, or character. 2. Made by applying cannabinoid concentrates or extracts to commercially available candy or snack food items. 3. Contains dimethyl sulfoxide or TMSO. Permitted marijuana forms. Dispensaries and cultivation centers may dispense or distribute marijuana in any form deemed safe, which allows patients to eat, inhale, or use it for medical purposes, and it will be subject to testing for quality assurance or QA and safety purposes. Security surveillance. A dispensary or cultivation center will be required to operate and maintain in good working order a 24-hour, 7 days a week, a closed-circuit television or CCTV surveillance system on the premises that complies with the following minimum standards. 1. Visually records and monitors all building entrances and exits, all parking lot areas, and rear alley areas immediately adjacent to the building, and covers the entire inside of the facility, including all limited access areas and all areas where medical marijuana is cultivated, stored, dispensed, or destroyed. Fixed cameras will be installed to provide a consistent recorded image of these areas. The company or individuals will install surveillance cameras to maximize the quality of facial and body images and to avoid backlighting and physical obstructions. 2. Cameras installed outdoors and in low-light interior areas will be day or night cameras, with a minimum resolution of 600 lines per inch for analog or D1 IP, and a minimum light factor requirement of 7/10 unit of the luminance or LUX. The installation of additional lighting may be required to increase picture clarity and brightness. Then cameras will be calibrated and focused on maximizing the quality of the recorded image. 3. The recording device will be a digital video recorder that meets the following minimum standards. Displays a date and timestamp on all recorded videos. can produce a video disc, CD or DVD, directly from the DVR unit using an installed media recording drive, and will be viewable on any Windows personal computer or PC, and include any required player software on the disc. 4. A display monitor with a minimum screen size of 12 inches will be connected to the electronic recording security system at all times. 5. Electronic recording security systems are required to be maintained in good working order at all times, and each manager, employee, or agent overseeing the functioning of the video recording security system to immediately report any malfunctioning or technical problems with the system. 6. Security recordings will meet the following minimum requirements. The recorded image resolution will be at least T1. The recorded image frame rate will be at least 3 frames per second during an alarm or motion-based recording. 7. Security recordings will be retained for a minimum of 30 days, and the recording system must be located in a locked, tamper-proof compartment. A cultivation center or dispensary will be prohibited from taping over existing security video from the last 30 days. 8. Upon request, the recording will be turned over to MPD or the Department of Health or DOH. Security alarm system. A dispensary or cultivation center will install, maintain, and use a professionally monitored robbery and burglary alarm system, which meets the following requirements. 1. The control panel will be a UL-listed burglar alarm control panel. 2. The system will report to a UL-listed central monitoring station. 3. A test signal will be transmitted to the central station every 24 hours. 4. At a minimum, the system will provide coverage of all facility entrances and exits, rooms with exterior windows, rooms with exterior walls or walls shared with other facility tenants, roof hatches, skylights, and storage rooms that contain safes. 5. The system will include at least one hold-up alarm for staff use. 6. The system will be inspected, and all devices will be tested annually by a qualified alarm vendor. A dispensary or cultivation center will maintain for 3 years reports of incidents that triggered an alarm. Such reports will be made available to the Department of Health or DOH during any inspection of the facility. A dispensary or cultivation center will notify the DOH by electronic means within 24 hours of any incident in which theft, burglary, robbery, or break-in occurred, whether or not items were removed from the facility. The facility manager will follow up the initial notice with a written report, describing in detail the factual circumstances surrounding the incident, and include an inventory of all stolen items, if applicable. Valid photo identification. A dispensary will refuse to sell or deliver medical marijuana to any person who fails to produce both a valid registration card issued by the Department of Health or DOH and a valid government-issued photo identification document displaying proof of age that matches the name on the registration card. Point of sale or POS system. The DOH may require a dispensary to purchase and participate in a point of sale or POS computer system for purposes of verifying that a qualified patient or caregiver is registered, verifying which dispensary a patient is registered with, tracking the quantity and date of each marijuana sale. Sign requirements. A dispensary will post at its building entrance in a conspicuous place a sign from the Department of Health or DOH that states, "Persons under the age of 18 are precluded from entering the premises unless they are qualified patients and are in the presence of a parent or guardian. Smoking, ingesting, or consuming marijuana on the premises or in the vicinity of the dispensary is prohibited. Marijuana will be used only by the patient in their home, the facility where they reside, or a medical facility when receiving medical care for a condition, if allowed by the medical facility." A dispensary will post a sign provided by the DOH that is either visible from the point of entry or the point of sale or POS, which indicates the following: The patient or caregiver must produce a valid registration card issued by the DOH. The patient or caregiver must produce a valid government-issued photo identification document, displaying proof of age that matches the name on the registration card. The use of medical marijuana may impair a person's ability to drive a motor vehicle, aircraft, or motorboat, ride a bicycle, or operate heavy machinery. The sale and use of marijuana and its diversion for non-medical purposes, including to a third party, is a crime in violation of D.C. law. A cultivation center or dispensary will post a sign, provided by the DOH, at all areas of ingress and egress to limited access areas, which reads, "Access to this area is restricted to persons registered with the department, visibly displaying a registration identification card." The dispensary will conspicuously post a sign in the area of the dispensary that is accessible to registered patients and caregivers, or make a booklet or other document readily available to the dispensary's registered patients and caregivers, containing the current retail prices of all items available for sale within the dispensary. Staffing and facility lighting. Required staffing levels. Dispensary will be staffed with at least 2 persons during its hours of operation. Cultivation center will be staffed with at least 2 persons when employees are present inside the cultivation center. Outdoor lighting requirements. A cultivation center or dispensary will be required for security purposes to have sufficient lighting outside of the registered business each day, between sunset and sunrise, that adequately illuminates the cultivation center or dispensary and its immediate surrounding area, including storage areas, parking lots, entry areas such as the front facade, and any adjoining public sidewalk. Outdoor lighting will be hooded or oriented to deflect the light away from adjacent properties. Limited access areas. Medical marijuana will only be grown, cultivated, stored, weighed, displayed, packaged, sold, or possessed for sale in a limited access area under the control of the cultivation center or dispensary, and they will permit only those persons registered with the Department of Health or DOH to enter these limited access areas. A limited access area, including all areas of ingress and egress, will be designated on its application. So limited access areas will be either a building, room, or other contiguous areas on the registered premises. A cultivation center or dispensary will post a sign, provided by the DOH, at all areas of ingress and egress, identifying the limited access area. Persons registered by the DOH will wear their registration identification, issued by the mayor at all times while working or entering the limited access area. It will be a violation for anyone to be located within a limited access area unless the person's registration identification is visibly displayed. Manufacturing standards. In the course of producing and growing medical marijuana, a cultivation center is forbidden from using any of the following substances or techniques: synthetic pesticides, for example, defoliants, desiccants, fungicides, insecticides, rodenticides, etc., or wood preservatives, example, arsenate. Fertilizer or composted plant and animal material contains substances prohibited. Sewage sludge, example, soil amendment. Synthetic growth regulators. Synthetic allopathic veterinary drugs, example, antibiotics, parasiticides, etc. Synthetic processing substances, aids, ingredients, food additives, processing aids, example, sulfates, nitrates, nitrites, etc. Equipment, packaging materials, storage containers or bins, example, contain synthetic fungicides, preservatives, or fumigants. Pesticides, fungicide, fertilizers, rodenticide, or drug banned by the Department of Agriculture or DOA, or Food and Drug Administration or FDA. Pesticide not allowed, example, by law, etc., and any other substances or techniques deemed unlawful. In the course of harvesting marijuana, a cultivation center will not harvest before the plant is 60 days old, starting from the day the seed or clone is planted. The prohibition on synthetic growth regulators will not preclude a cultivation center from using artificial lighting or lighting equipment. A cultivation center will obtain written approval before engaging in the use of butane or other explosive gases to extract or separate resin or tetrahydrocannabinol, or THC, from marijuana, or to produce or process any form of concentrates or infused product. Allowed pesticides. Pesticides may be legally used on medical marijuana by cultivation centers under this criterion. Any pesticide used in marijuana cultivation must be registered with the Department of Energy and Environment, or DOEE. The use of any pesticide used in cultivation must comply with the regulations promulgated by the DOEE. Any pesticide registered with the DOEE may be used following its label or labeling directions for cultivation in Washington, D.C. under the following conditions. For products registered by the Environmental Protection Agency, or EPA, all active ingredients of the pesticide product are exempt from the requirements of tolerance. The pesticide product label allows use on the intended site of application. The pesticide product label expressly allows use on crops or plants intended for human consumption. The active ingredients of the pesticide product are allowed for use on tobacco by the EPA. The Department of Health, or DOH, has the authority to permit the use of a pesticide product that does not expressly allow use on crops intended for human consumption if the active and inert ingredients. The pesticide product label allows use on the intended site of application. The active ingredients of the pesticide product are allowed for use on tobacco. The pesticide product label specifically allows its use on marijuana. Use minimum risk pesticide products. The pesticide product label allows use on the intended site of application and allows use on crops or plants intended for human consumption. Pesticide products with a Special Local Need registration issued in the Federal Insecticide, Fungicide, and Rodenticide Act allow its use on marijuana. The DOH may prohibit the use of any pesticide product for the cultivation of marijuana if they determine that such use poses a significant threat to public health and safety or the environment. The use of any pesticide not specifically tested, labeled, and assigned a tolerance for use on marijuana is not recommended by DC because the health effects on consumers are unknown. The DOH may publish a list of pesticides that it has determined meet these criteria. Marijuana transportation. A cultivation center will obtain from the Department of Health, or DOH, a transport permit to transport within Washington, D.C. medical marijuana to registered dispensaries. An original transport permit will be required for each vehicle, designated by the cultivation center or its contracted agent to be authorized to deliver marijuana to registered dispensaries. A cultivation center or its contracted agent will not transport marijuana within D.C. without an original transport permit. A cultivation center will permit only an employee, director, officer, member, incorporator, or agent registered with the DOH, or its contracted agent to transport marijuana to a registered dispensary. Upon demand by a Metropolitan Police Department or MPD officer or investigator, the registered person in charge of the transportation for the cultivation center or its contracted agent will exhibit to the MPD officer or DOH investigator an original transport permit. Prohibited and restricted activities. Marijuana dispensaries. It will be unlawful for a registered medical marijuana dispensary to receive or purchase from a source other than a cultivation center registered in Washington, D.C. A dispensary will not be allowed to offer for sale, sell, or solicit an order for marijuana in person, except within the registered premises. Nothing limits a dispensary from providing Educational information regarding marijuana to a physician. Necessary information to qualifying patients over the telephone or online, including the availability at the dispensary of particular marijuana types, recommended by the patient's physician. A dispensary will not be allowed to receive or purchase marijuana from a person other than a cultivation center registered in D.C. Cultivation centers. A cultivation center will not be allowed to sell medical marijuana to qualified patients or caregivers, and it will be a violation for a cultivation center to sell marijuana to them. It is illegal for a cultivation center to sell or distribute marijuana to a person or entity other than a dispensary registered in Washington, D.C. Also, it will be unlawful for a cultivation center to sell marijuana from plants not grown at a registered location in D.C. Marijuana delivery and plant limitations. A dispensary or cultivation center, dispensary, will not be allowed to transport or deliver medical marijuana to a qualified patient or caregiver, or directly from a cultivation center. It will be a violation for a dispensary to transport or deliver to either a patient or caregiver, or from a cultivation center. Cultivation center will not be allowed to deliver marijuana to any premises other than the specific registered premises of the dispensary where it is to be sold. Plant limitations. A cultivation center will be permitted to possess and cultivate up to 95 living marijuana plants at any one time, for the sole purpose of producing medical marijuana. A dispensary will not be permitted to possess or sell marijuana plants. It will be a violation for a dispensary to possess or sell marijuana plants, or for a cultivation center to sell marijuana plants to a dispensary. On-premise consumption. A cultivation center or dispensary will not permit the consumption of medical marijuana at the registered premises in any form. They will dispense or distribute marijuana in a closed container that will not be opened after the sale or the contents consumed on the premises where sold. A dispensary may exhibit for display purposes only clear jars of marijuana, to assist patients in making informed purchase-making decisions. It's illegal for a cultivation center or dispensary to have on the registered premises any marijuana or paraphernalia that shows evidence of it having been consumed or partially consumed. Tie-in purchases. A cultivation center will not require, directly or indirectly, a dispensary to purchase any marijuana type or other commodities to purchase any other products. Agent entry requirements. In Washington, D.C., the following laws must be followed. A person under 21 years of age will not be employed by a dispensary to sell or dispense medical marijuana. A person under 21 years of age will not be employed by a cultivation center to grow or cultivate marijuana. A person under the age of 18 will be precluded from purchasing marijuana from a dispensary, unless they're a qualified patient and is in the presence of a parent or guardian. A dispensary may prohibit an individual who is not a patient, caregiver, or an official government business from entering or remaining on the registered premises. Physician compensation or gifts. It will be a violation for a cultivation center or dispensary, or a director, officer, member, incorporator, agent, or employee of a cultivation center or dispensary to provide financial compensation, an office, or anything of value to a physician who recommends the use of medical marijuana, and a cultivation center will not be allowed to hold educational seminars, classes, or discussions regarding marijuana for physicians. Marijuana and paraphernalia and visibility. A dispensary will not provide a qualified patient or caregiver more than 4 ounces of dried medical marijuana, or the equivalent of 4 ounces of dried marijuana in a form other than dried, either at one time or within a 30-day period. A dispensary will dispense marijuana and distribute paraphernalia only to a patient or caregiver if the patient is registered to receive it from that dispensary. Visibility. A dispensary or cultivation center will not permit marijuana or paraphernalia to be visible from any public or other property not owned by them. Advertising, promotion, and marketing. Sign advertising. Advertisements relating to the prices of medical marijuana will not be displayed in the window of a registered establishment. Advertisements relating to marijuana will not be displayed on the exterior of any window, or the exterior or interior of any door. No sign advertising marijuana on the exterior or visible from the exterior of any registered establishment or elsewhere in D.C. will be eliminated at any time. Prohibited statements. A registered cultivation center or dispensary will not use any picture or illustration that depicts a child or immature person or objects, for example toys, suggestive of the presence of a child, and any statement, design, device, picture, or illustration designed to be especially appealing to children or immature persons. A statement that is known by the dispensary or cultivation center to be false or misleading, concerning the advertised price charged to the qualified patient, ingredients of marijuana, source of the manufacturer, or statements as to health benefits will be prohibited. A statement that encourages the use or purchase of marijuana without a registration card will be prohibited. Records and reports. Cultivation Center Records. Each registered cultivation center will keep and maintain upon the registered premises true, complete, legible, and current books and records, including the following. 1. Date of each sale to a dispensary. 2. Name, address, and registration number of the dispensary. 3. Quantity of medical marijuana and paraphernalia sold to the dispensary. 4. Price charged and the amount received for the marijuana from the dispensary. 5. Quantity and form of marijuana are maintained at the cultivation center daily. 6. The number of plants being grown at the cultivation center daily. These books and records will be maintained by the cultivation center for 4 years. Invoice records and transactions. The books and records should include the original and duplicate invoices that will be open to inspection by the Department of Health or DOH, or its designated agent, and the Office of Tax and Revenue or OTR, during the establishment's approved hours of operation. A cultivation center and dispensary will keep and maintain all books and records for 4 years after the latest transaction recorded in those books and records. Reporting employee changes. A cultivation center or dispensary will notify the mayor within 10 days after a registered director, officer, member, incorporator, agent, employee, or manager ceases to work at, manage, own, or associate with the operation, and they will surrender their identification card within 10 days of ceasing their association. Cannabis driving and impairment. Commercial and public vehicles. No driver of a commercial or public vehicle in Washington, D.C. will have in their possession, while in or on the vehicle, any opened or unsealed package containing medical marijuana. Anyone driving in D.C. gives implicit consent to a chemical test. If a driver refuses to submit to a test, they will be informed that their license will be revoked for 12 months. Evidence of a refusal to submit to a test will be admissible as evidence of guilt in a court of law. Standardized field sobriety tests, or SFSTs, that may be administered by trained drug recognition experts, or DREs, include breath test instruments, urine tests, and blood tests. Penalties. First offense, incarceration for no more than 90 days. $3,000 fine, or both. 6 months suspended driver's license. Second offense, 5-day minimum incarceration up to 1 year, $1,000 to $5,000 fine, or both, and 1 year suspended driver's license. Third and subsequent offenses, 10-day minimum incarceration up to 1 year, $2,000 to $5,000 fine, or both, and 2-year suspended driver's license. Thank you for viewing Washington, D.C. marijuana laws.